Well, it is noon. Scott, in the interest of time and the number of people here joining us, shall we get started?
That sounds great. That sounds great. So we have got almost 60 people on the call so far, and it just the ticker keeps ticking off. So that's good
Yes.
news. Um, I'll kick it off just as a reminder. Your cameras are off. Everybody's on mute. So if anybody has questions, please put them in the chat, and then what we'll do is at the very end, I'll kind of relay those questions to Doug, and he can answer those time permitting. There is also a handout in the chat that there's a couple versions of it, or a couple copies of it that Elisa has uploaded. So why don't we get started? Oh, Allison, if you want to do your welcome, everybody, to the MAAR members.
Sure. Yep. Just welcome to Minneapolis Area Realtors members who are joining us here. This is a joint webinar that we are hosting with the National Association of Residential Property Managers. So just wanted to say a quick welcome. And again, if you have questions during the webinar, please don't hesitate to put them in the chat. So excited to be doing this today and hearing from Doug Turner. So go ahead, Scott.
Great, thank you. So as any of the NARPM members know, at the beginning of every one of our meetings, we do have a short antitrust statement. So and this will give everybody also a couple minutes to get back on the thing. So I'm just going to read that, and then I'm going to talk briefly about some of the benefits of becoming a NARPM member for anybody that is not. So getting started, NARPM is the premier professional association designed for real estate professionals who know firsthand the unique challenges of managing single-family and small residential properties. NARPM provides resources for residential property management professionals who desire to learn, grow, and build relationships. It is the policy of NARPM to fully comply with all antitrust laws. The antitrust laws prohibit, among other things, any joint conduct among competitors that could lessen competition in the marketplace. NARPM membership is composed of competitors. They must refrain from discussing competitively sensitive topics such as items related to pricing, fees, costs, rates, individual competitors, or specific business transactions, or controlling or allocating markets. So with that, with the antitrust statement out of the way, just a couple for those of you that aren't familiar with NARPM. NARPM is a national organization that's primarily focused on residential property management, which means that this is, the organization that dedicates and is centered on the topics that really matter to you as property managers. Minnesota has its own chapter. There are chapters all around the country. And, it's really also a good opportunity for you just to learn more, increase your knowledge about it, talk with other peers, share horror stories. And then also it's an opportunity to increase consumer confidence because as you get your NARPM membership, it's one additional logo that you can add to your business slide, add to your website that says, look, we are adhering to the highest standards and principles of the industry, and we are professionals at this. So just two other data points. This is, we try to have meetings once a month. Our next meeting is going to actually be a happy hour in November. So then we're going to take the month of December off, and we'll be back in January. So if you are interested, please reach out to one of the members, reach out to me. We'd love to talk with you about it. So Allison, if you want to take it away.
Yeah, thanks so much. Just wanted to share a little bit about MAAR. Founded in 1887, Minneapolis Area Realtors is the largest local realtor association in Minnesota, supporting and connecting over 9,000 realtor members. MAAR invests in education and the economy and holds its members strictly accountable to the NAR Code of Ethics and Standards of Practice. MAAR's mission is to provide the resources and leadership for realtors to succeed while promoting stronger, sustainable communities. MAAR's mission is to ignite professional success and grow vibrant communities as the expert resource and trusted leader in the residential real estate industry. Go ahead, Scott.
Thank you. So we will jump into our main topic. I'll give you some background on our speaker. Doug Turner is an attorney and partner at Hanbery Turner. He has been practicing law since 1997, primarily representing landlords in landlord and tenant matters, advocating for the property rights of owners, managers, and operators of multifamily and commercial properties. He's also an investor and a landlord himself. So he understands what we all go through. His practice focuses in the areas of fair housing and disability defense, eviction actions, defense of tenant litigation against the landlords, and representing commercial owners in evictions and general litigation. Doug is also a member of the Minnesota Multi-Housing Association and multiple what's the word I'm looking for, Doug? Multiple
law-related organizations. That's fine.
There you go.
Nobody pays attention to that anyway.
So take it away, Doug. Thank you so much for help, doing this today.
Thank you, Scott, for that introduction. And I'll just say, from the outset as well. So I've provided to both organizations kind of an outline of the new legislative changes. And at the back of that outline, obviously I have to say this as all people know, that this sort of an education doesn't create an attorney-client privilege. And I'm not your attorney. And if you have a specific legal problem or question, please, you will need to seek the advice of an attorney in the area of landlord-tenant law. So with that said, I started doing this in 1997, and then it was pretty run of the mill as it relates to evictions and representing landlords. And our firm, we represent lots of different kinds of landlords, from the very small to a very large landlord. So we have a vast array of clients. We have a vast array of clients with affordable properties, with market rate properties. And so we run into a lot, as you probably can imagine, litigation. I'm going to fast forward just quickly as a little history and tell you that, the world changed, as you guys are aware, back when COVID hit, March 18th of 2020. And I was looking back at all the orders, the executive orders that Governor Walz put in place to limit the ability of landlords to move forward in their evictions. And as I was looking at some of those orders, I was also reviewing, how many evictions and how many landlord-tenant problems actually kind of exacerbated over those years. And so it's been kind of a wild ride. And just when we believe that things are getting back to normal, meaning the backlog in most counties is caught up. I do evictions in all counties. Most counties in Minnesota, all 86 except Hennepin, are still remote. Hennepin is in-person hearings, Tuesday, Wednesday, and Thursday, a morning calendar and an afternoon calendar. So that's kind of the lay of the land as it relates to where we've been and here we are today. And then, as you know, when the last executive order expired, when the door kind of opened, that landlords could then file evictions because, well, the legislature forced Governor Walz's hand, and so then the door was kind of opened at that point. And then I think what happened was, then you saw, elections take place, and because of, this is no secret. If it is a secret, you need to crawl out from under the rock that you're in. But since the House was governed by the Democrats and the Senate Democrats, and then Governor Walz obviously is Democrat, they pretty much had, the word that they've used is the trifecta. And I think what came out of that was a I haven't used this word very often, a historic. I mean, it's historic. Sweeping landlord-tenant law changes. And not all good for landlords. And so what came out of that was 24 or 25 pages socked into a 485-page omnibus bill. And so what I want to try to go over with you today is, since I've kind of given you that history, is to talk about what I think is going to be most important come January 1st, 2024. And I want to talk to you a little bit about, and if you have the materials in front of you on page 2, there's a brand new law, and it's probably the most important one that your clients and that landlords and owners will face, is beginning January 1st, 2024, every eviction statewide, if it's for non-payment of rent, must have a 14-day eviction pre-filing notice. And if you see me looking away, ladies and gentlemen, I'm just looking at at the outline you're looking at. So I'm not playing games or, whatever. So, and so looking at the new 504B321, there are certain things that must be in the notice. And this is so important. And when I do lots of trainings on this, and I train our clients, the most important takeaway is you must not deviate. Don't try to summarize it. Don't advise your clients to summarize it. Use the exact words that the statute requires. So the statute requires, as you can see, A through G in this outline, okay? A through G, you've got to put the total amount due. You've got to do a specific itemization. Again, do not put the tenant owes $14,000, okay? We are advising our clients to attach a ledger, okay? The name and address of the person authorized to receive rent, that has to be in this notice. And then if you look at D, E, and F, and G, those are the exact words, this is no trick, exact words out of the statute that I'm advising my clients and landlords to do when tenants haven't paid rent and there is a need for an eviction. So what does that mean? That means you have to prepare when I say the proverbial you, I'm going to assume landlord, owner, so I'm not going to characterize it any other way. The landlord would have to then prepare this notice, written notice, and then deliver it. Either, if you look on page 3, it either has to be done personally or by first-class mail to the tenant's residential premises where they live, okay? Now, you see in that notice, I put or, okay? The statute says or. Not giving you legal advice. My recommendation is do both. My recommendation is mail it. My recommendation is advise people to go and hand it to the tenants. If you can't put it in their hands, consider posting on the residential premises so that there is absolute proof that this requirement was completed. Because what they come to court and say is, I never got the first class mail. I get my mail every day. I go to the post, I go to the box every day. I didn't get this. So there's all of a sudden a shifting presumption right out of the gate that the landlord didn't mail it. So I can't stress this enough that, and I think this new 504B321 will be a huge problem for landlords in the state. It's going to be a huge problem for the small landlord. It's going to be a huge problem for the big landlords, because what I see people do with notices that we have to give now, people like to alter. People like to take a notice I give and change the words. It's not very smart when your lawyer gives you the document to use and you want to cut and paste and change the words. So you've paid for legal advice and now you have changed the words. Good luck. when you change the words that I give. So it's very important, and that's probably the biggest change, because right now, in contrast, there is no notice required statewide. So you can bring an eviction for non-payment of rent, and there's no notice required, except in Minneapolis, there's a 14-day notice right now. St. Louis Park has a 7-day required notice. Brooklyn Center has a 30-day required notice. Now, when January 1st hits, anybody with properties in those 3 cities must give that particular notice, and that's particular language that, again, our firm has prepared right out of the ordinance itself. We're not making it up. We're not trying to reinvent the wheel. We go to the ordinance and copy the language. So January 1st, 2024, a landlord in those 3 cities will be required to give a pre-filing statewide notice along with a Minneapolis, St. Louis Park, or Brooklyn Center. If you don't have properties in those cities, the only thing that is required statewide is the pre-filing notice, as I have delineated that in 504B 321. So that's a big deal. I think what we're going to see is evictions taking longer. We're going to see landlords probably not getting notices out as soon as they should. Then you have to wait the 14 days, then you file the eviction on day 15 or 16. By that time, you're going to be at least 2 months into the game, right, of the resident owing at least 2 months rent. So I think the takeaway is get your notices ready as quickly as possible. I don't care what the lease says about the late fee. I hear this all the time. Well, the lease says the rent's not due to the 5th. I'm like, no, that's not what the lease says. Rent is always due on the 1st. A late fee may apply on the 3rd, 4th, or 5th, but that doesn't stop you from putting out your notices on the 2nd or 3rd, starting that 14-day notice period to run. Because I'm telling you, ladies and gentlemen, the residents are going to find out pretty quick that they don't have to pay rent. They don't have to pay rent until they even get that notice. So they're not going to do anything. So now, again, this overshadows, obviously, the thousands and thousands and thousands of great residents that we rent to, right? I mean, it's frustrating that the good residents don't have any rights, and the residents that are maybe delinquent or lease violators, they seem to have all the rights. And so very frustrating. I get it. I'm in court every day, all day, and I have those same frustrations. So that one is big, and I can't stress enough that January 1st, 2024, and I'll see lots of cases getting dismissed because probably some of my clients, unfortunately, and some smaller landlords and some medium-sized landlords will not give proper notices, and the cases will just be stopped in their tracks for a new 14-day notice. So very important. I'm gonna switch gears a little bit because I think that at the outset is one of the largest changes that I think you'll see. Now, remember, I've been dealing with giving notices due to the executive orders and the virus all these many years. So it's normal place for me to be given notices, but I think it's going to be a real change and something hard to get your arms around.
Doug, I've got I'll probably just interrupt you for 2 questions that came in about this topic. So let's just go through them. They're similar. One is, can we send the 14-day messages overnight delivery with delivery confirmation versus US postal mail? And then the second is related is, if you elect to mail the 14-day notice, do you need to account for mailing time, or does the date start on the date on the top of the piece of paper?
I think that, again, I took this right out of the statute. It says first class mail. So okay. And again, it's a good question, because the statute does not talk about receipt. It talks about the landlord's obligation to give the notice. That means mail it or deliver it. And we argue about this. Tenant advocates will come and say, well, they never received it. And it's just like, hang on, time out. The statute doesn't talk about receipt. If I had to prove that Scott Fisick received everything I sent him, I would never win any case, because I could never prove it. I could never prove that you went to the mailbox on January 3rd and got the letter. I mean, and so we see that as kind of a red herring. We see legal aid kind of throw that in every now and again, but it's just delivery. It's just delivery. And the more ways you can deliver it, the better. Now, I think overnight mail is first class mail. I think you're good in that regards.
Okay. So over first class mail. So maybe we do first class mail and we do overnight mail and we send them an email, kind of, throw all that out. Okay.
You absolutely can send, you can absolutely post and emails. The more ways you do it, the better. I mean, because it's just going to show that you did everything in your power from a landlord perspective to deliver the notice. And when the tenant comes to court, if she does, and says, I never got anything, the court's not going to believe it. So, I mean, the more delivery, but the only ways the statute says complies is personally or first class mail. So, but we're going to tell everybody to do every way possible.
Okay, thank you.
So I'm gonna switch gears a little bit and go back to the first page of the handout to talk a little bit about what I believe is the next big problem that's going to face landlords January 1st, 2024. And that's 504B 120, disclosure of fees, utilities on the front page of the lease. So what this new, and again, this is come January 1st, 2024. So those leases that are in effect are still valid, are still okay to use. But if you enter into new leases come January 1st, 2024, you must have a lease that has every charge on the front page. So those of you that have potentially, obviously the rent, late fees, utilities, all of those, every charge needs to be on the first page. We are recommending, we've done some kind of a data box on the first page of the lease. I think that is a good way to display the information. And I think it's important to use the words that, and this is out of the statute as well, use the words total monthly payment. Okay, total monthly payment. It, should be in bold in that data box on the first page. This is how much you owe. Now, if the late fees don't kick on until the 4th or the 5th, you need to make another line item, right? That on, January 5th, the total monthly payment will be $1,300 plus 8% of $1,300, right? I mean, so just understand that every financial item should be on the first page of the lease. And the problem, and I'm going to have lots of clients with this problem. I mean, I've reviewed tons of leases, and there's tons of leases that my clients use that aren't going to be compliant come January 1st, 2024. And the problem that I see is the penalty. The landlord is liable to the tenant for treble damages and, the bad news, reasonable attorney's fees. Treble damages, triple damages. So if you charged them $150 for utilities and it wasn't on the first page, they can sue you for 150, treble that, plus if they get an attorney and prove that you violated 120, then you potentially could see attorney's fees being awarded to the other side. So in addition to the attorney's fees that you're going to pay to your own lawyer. So very important, and that front page disclosure also be mirrored in any of your advertisements as well. So again, for leases that are now in effect, you're golden, okay? But for leases new leases beginning January 1st, you really need to take some time now to think about, do I need to change my lease? Do I need to make sure that data box is on the front page? Do I need to put a section in there that talks about who the landlord is? I call that a 504B 181. The name and address of the landlord and who can receive and give receipts for rent. It's another big one that I see that's not on the front page of the lease. And if I see it, I don't see it consistent. I see an LLC on the page of the lease, and then I see Doug Turner's property management firm on letterhead. And I can't stress enough that the lease, and again, this is a little bit off topic of 120, the lease disclosure, ABC LLC, should be in every letter that you send. ABC LLC, the address at the top, the letter is from the LLC landlord. It's not from the property manager. It's not from, the maintenance guy. So I can't stress enough that this is a good time to start thinking about, do I have those provisions? Do I have a partial payment of rent clause in my lease? Again, those aren't new things. They've been around for quite a while, but it's just those things that I see that in addition to that disclosure, and I call it kind of the above the line disclosure, should also be reviewing what other lease provisions you may need to make sure when whoever goes to court for you, you can properly litigate and enforce your rights. Because I'm just here to tell you, ladies and gentlemen, it's tough. It's tough to evict people these days. It's not easy. Some counties are better than others, but we face an uphill battle. And if they can find either the court or tenant advocates can find one thing to have your case thrown out, they will. And then the case will also be expunged. So I can't, so that's the next kind of big issue that you're looking at, I think, from a landlord-tenant perspective, is a review of your leases that are going to come in, take effect January 1st, 2024 after.
Doug, two questions that came in. One is that if the lease specifies that email is, can be used as written notice to the tenant, I'm assuming the statute probably overrides that. And then secondly is, will the Minnesota Bar release a new state bar lease on January 1?
I don't know that. I know the MSBA, that's what I call it, the Minnesota State Bar Association lease. I know that lease, and I know they have a big data box on their first page. I think, I'm assuming they will update it. It probably won't be in 2024, but I'm assuming they will update it as far as that goes. And then, and I've got my own thoughts on the MSBA lease. I don't think it is as friendly to landlords as I would prefer it if I was representing clients. It has some provisions that I really like, but what the MSBA lease is try to equal the playing field. They want attorney's fees for tenants, and it's like, nope. It's just like but I do like that box, that data box, as it relates to the email issue. I think for regular notices and letters and communications that the landlord sends to the tenant, if there are provisions in the lease that talk about email is satisfactory and you agree in advance to receive those notices, I think you're fine. Late rent notices, hey, you violated the lease, you have an illegal whatever, blah, blah, blah. Totally fine. When it comes to this 14-day notice, no. The 14-day notice that's prescribed by law must be delivered in the ways that are set out. Now, you can certainly email them a courtesy copy, and that's what I would recommend. Please find the attached courtesy copy of the pre-filing eviction notice. Thank you. So that's my answer on that. So again, I think, just be careful. I can't stress enough. Again, this is not necessarily new, but I mean, document. I mean, I know people get text messages, and I know people like to send 2-sentence emails, and I'm just opposed to it personally. It's not illegal, okay? It's not wrong. But I think there are better business practices that landlords can do. And sometimes sitting down at the computer and writing a letter, and maybe you're going to PDF that letter and email it to them. But emails in general and text messages in general do not play nice in court. I would still rather have a good old-fashioned letter that I can ask you a question and say, did you draft this letter? Yes. When? How'd you deliver it to them? Right? And we can talk about the letter. And I don't have to worry about an email. I don't have to worry about the resident saying, well, that email isn't valid anymore. My phone got stolen. I mean, you hear it all. So with a grain of salt, use that way of communication at your pleasure, I guess. But still, for me, the good old fashioned way is better. Writing letters, and because I've reviewed thousands and thousands of letters since 1997. People are more thoughtful when they have to sit down and write it out. More thoughtful versus I'm mad as heck and I want to write this email because I can't stand it anymore. And it's just people are more thoughtful when you have to sit down. And I know you hate that. Trust me, I'm in the letter writing business. I mean, I get it. So just keep that as a business practice, practical takeaway, I guess, and use it at your peril or at your pleasure. Getting back, so the next big issue which I want to talk about is entry. And that's on page 1, 504B 182. So right now, the law says very clearly, if I want to come into my tenant's property, I have to give a reasonable notice. Now, legal aid and everybody else says it's 24-hour written notice. Nope, that's not what the law says today. It says reasonable notice. And if you communicate that reasonable notice by knocking on the tenant's door and saying, hey, can I come in and fix so-and-so? And the tenant says yes, then guess what? That's reasonable notice. If you call them up and they say, hey, I need my kitchen cabinet fixed, can you come over right now? Yes. I mean, so we get this idea that reasonable notice must be 24-hour written notice, and that's not the current law. Okay. So I know from a practical standpoint, most of my clients give a 24-hour written notice because you're not going to run over there at the drop of a hat unless it's an emergency. So this new entry law 182 talks about it's going to change to a 24-hour written notice prior to entry. And if you look to see what's required, it must specify a time or anticipate a window of time between the hours of 8 a.m. and 8 p.m. Don't have so much issue about the 8 a.m. to 8 p.m. Unless the landlord and tenant agree to an earlier or later time. Now, see, we're getting into, I mean, how do we agree to an earlier or later time? I mean, so this is where your practices and procedures are going to have to be dialed in. I wouldn't amend any times unless we do it in writing, because the minute you show up and they're going to say, what are you doing here? You see what the penalty is. You go in, the penalty is $500 plus, again, the dreaded reasonable attorney's fees. So you go in without a written notice. Tenant can bring an action, an affirmative case against the landlord that says you violated 182. A violation of 182 is also a violation of the covenants of habitability. That talks about what the landlord's duties and responsibilities are. I won't bore you, but it gets them $500 civil penalty, which is a payment probably to the court. When you see civil penalty, I don't think the tenant gets a civil penalty. I think the court or the governing authority gets the civil penalties. At least that's what I think. We haven't seen this in practice yet. But the bigger thing is the attorney's fees. They're going to get an attorney, and then they're going to ring you up for reasonable attorney's fees. And so can't stress it enough that, not doing things in writing is going to be a problem. So you must be able to shore those business practices up now, so you're not running in there. Now, does this apply to emergencies? They didn't change the rule as it relates to emergencies. So if it's an emergency, no heat, no water, buildings burning to the ground, whatever the case may be, you can go in without proper notice. But remember, do everything in your power to give notice, number one. And number two, you have to leave notice in the unit that you were in there on an emergency. And my recommendation is cover your you-know-what. Take a picture of the notice. Post it, put it, if you're in there on an emergency, put it on the kitchen table. Take a picture of it. Get done with the emergency, call the tenant. Hey, I was in your unit on an emergency. This is what happened. I mean, document, so that you don't run into this problem. But I think I think that the 24-hour written notice is not going to be a big of an issue. It's going to be those landlords that just barge in regardless of whether the tenant agrees or not. I've been involved in some cases where the tenant puts in a work order to one of my clients, and then the work order says a question that the tenant answers on his or her portal: can we come in to do the work? She writes no. So, I advise my clients now, we put her on proper notice and we go in, we give her reasonable notice. Now, conversely, if she says, yes, come on in and fix my bathtub in 2024, now I would say, go on in. The tenant's consented, you're fine. In 2024, I don't know. I don't know. I would probably still give a written 24-hour notice, even though it says, that can be waived by agreement of the parties. I would just rather give the notice and go in properly when I can document that here's my 24-hour written notice and here it is. So can't stress that enough, that I think that's going to be a pretty fertile ground for tenant advocates to come after landlords for penalties and the dreaded reasonable attorney's fees.
And Doug, a lot of our technology these days has the ability for us to text tenants through our technology, and the responses are not in your phone, but actually on the technology. Would you be satisfied that that's quote unquote in writing?
I guess my question back is, are all those text messages then saved forever?
Yes.
Yeah, I mean, I think that gets us where we need to be. It does say in writing, but I think we'll see. I don't know if I would test that out right away, but text messaging, because then we still get into the whole idea of I didn't get it. I don't know if they respond back right away, they got it. I mean, clearly, but I don't think the legislators kind of understand that's maybe a way that landlords and tenants communicate these days.
And
So
then somebody has a question, says, can you have the tenant sign a letter of approval when you enter? I'm not sure if they mean.
you mean
Angeline?
a permission or a consent?
Yeah, I don't know what that, maybe.
Yeah. Yeah, you could take, I mean, I'm envisioning it this way. You could take a clipboard full of permissions, and before you go in, you could have the tenant sign, I, Jane tenant, agree that the landlord can come in and fix my whatever. Yeah, absolutely.
Okay.
Yeah.
Okay.
If you can carry that clipboard around and do it, that is a very good way, because if the tenant permits you in, I would argue that you don't have to give a notice. You know, if the tenant calls you and you happen to be walking down the hallway and our toilet's leaking, and the tenant says, hey, come in, can you come in real quick and check my leaky toilet? I think I would say, yes, but you need to sign this consent that I can come in today. In the good old bad old days, that'd be reasonable notice. You would go in and just make the repair. Without that agreement, I think the tenant could come back later and say, nuh-uh, landlord came in, didn't give me a written notice, I'm entitled to the $500 civil penalty or an award for that. So, I mean, we'll see. I mean, maybe there's not going to be that sort of litigation, but I'm nervous about that, to be honest with you. Another big area that I think the next area that we're going to see that is fairly a big deal is the inspection rights. So 504B 182 talks about initial inspections and final inspections. And this is going to be a real problem for our clients and landlords and property managers in general, because in the hubbub and the hectic day-to-day, when tenants are trying to move in general, they're not worried about inspections, right? In today's times, what they do, most of my clients say, here's the move-in checklist, right? Please return it to us within 7 days. Well, I think those days, we'll see, may be over, because giving the tenant possession prior to the 14-day or prior to the initial inspection is a problem. And you can see in the materials, it says, in lieu of an initial inspection or move out, when a tenant agrees, a landlord may provide written acknowledgement to the tenant of videos or photos or videos of the rental unit and agree to the condition of the rental unit at the start or end of the tenancy. So the best practice would be, don't give anybody possession until you've done a couple things. You've either actually done the walkthrough and you've marked up, this is okay, this is bad, this is okay, whatever the case may be, or you have videos or photos that you can deliver to that resident right on the spot. And if you're going to do something like that, I would recommend having, again, documentation. Tenant agrees the condition of the unit. She's received the photos. She's received the videos, and she agrees that the unit is, in good condition and no repairs need to be made. Something, you know what I mean? Something like that. So, and again, I know how this works. I've done this too long. I've moved in enough tenants. I've done move in and move out inspections. I know it's hectic. I know you get the calls. I just need to get in today. Can you let me in? When you have painters and contractors and people in the unit finishing the work. My answer to that is a hard no. I don't care about your situation. You're not moving in early. That practice needs to stop. I can't stress it enough how much litigation we've been involved, because some landlord feels sorry for somebody. The days of feeling sorry for the tenants is over. They got us by the short hairs, you guys. So, and they will exercise their rights. and they will exercise them hard and fast against you. Trust me. So my recommendation is do the turns, take good pictures, take good videos, get the proper lighting. When that unit is turned and it's beautiful, because I know it, I've seen them, and I know you guys put out good work and great product out there. Take good lighting, get good lighting in there so you can take pictures, so I can see how beautiful those walls are, so I can see how beautiful the flooring is, so I can see how new the appliances are. It only helps me when I'm litigating this case for you, because the tenant says you violated every law under the planet. So the move-in inspection rights, I can't stress it enough, is to make sure you are documenting that and you're taking good photos. Okay, so between every tenant, the tenant leaves, you're taking great photos, right, of the damages beyond normal wear and tear. Before the new tenant moves in, you're going back in and you're taking videos and photos of the turned beautiful unit, right? So you have a pictorial history of what that unit has looked like for 3 or 4 turns. And so can't stress that enough.
So Doug, here's the question that, I'm going to ask, because the statute, because we do that, before and after, but it says the landlord must notify the tenant of an option to request an initial inspection. So the way I read that is that's if the tenant ever says, yeah, I do want the inspection. So I send a message to the tenant, I want an inspection. If they never say that, then it says in lieu of an initial inspection, and when the tenant agrees. So it's like, I'm not sure how to read that. It's kind of contradictory.
It's absolutely unclear.
Okay.
It's and our recommendation is, if the tenant does not ask when you give them the option to do the initial inspection, I would give them the videos and the photos.
Send them over.
Have documentation that either you hand them physically to them at the signing of the lease, or you're emailing them to them. Hey, here's the condition of the unit. Because what they're going to do, it's revisionist history, right? They're going to come back at a conciliation court hearing and said, I never got an option from Scott Fisick. He's an awful person. He never gave me that notice. And then there's a penalty for that. Treble damages and reasonable attorney's fees. So I don't know how this litigation is going to play out. I think it's going to play out in conciliation court with a lot of tenants saying, I never got that. And we're going to have landlords that are going to say, yeah, I gave it to her. I talked to her. We were in my office. And it's just like, was there anything in writing? No. And if you're going to give that option and she's going to decline it, I think you need something in writing. I declined the inspection. I need to move in. I would still give the condition of the unit right there on the spot. So it is a little vague, and I think that is on purpose. You have people at the legislature that don't understand landlord-tenant law, and they don't ask the experts. So same thing with the move out. The move out, again, a reasonable time after notification of intent to terminate the tenancy or before the lease term shall notify the tenant in writing of the tenant's option to request a move-in inspection and the right to be present at the inspection. And again, you see, I put those words in quotations. Use that language in your correspondence. Dear resident, this is your notice that you have the right to request a move-out inspection and the right to be present at the inspection. Use the words. So, and that gets us to the damages. What they did, they amended 504B 178, which, if those of you that are familiar, it's the security deposit statute. So what they've done is they've said, if you fail to do this, okay, then you're liable for the tenant for the amount of the deposit withheld, interest thereon, and then the penalty in addition to the portion wrongfully withheld. So the reality of that is that you better have the documentation, and not giving it to them, in my view, nothing more than sets you up for a conciliation court complaint. I mean, it just does. I mean, they're gonna, if you give it to them, I think it's more likely than not, they say, yeah, hey, these pictures are pretty nice, and they're not gonna sue you when you wrongfully, or when you withhold the deposit. Now, you can still withhold the deposit for damages beyond normal wear and tear. They just added that the tenant gets another hook in us to come back and say, nuh-uh, he never gave me, or she never gave me the initial move out notice. I never got anything in writing that on the move out. I wanted an inspection. Here's my email. Here's my text. That's what they're going to do. I can just tell you that. So that I think is going to be a big deal. I don't think that plays out as much in housing court as it probably plays out in conciliation court. Okay, which I'm not sure we get a fair shake in Hennepin County on that anyway.
I think this might be a quick, easy question or easy answer. It says, since many of us use online management software, and all photos and reports get uploaded into the portal where the tenant can view the information, but this doesn't happen until I get back to my office and the photos sync and such. It's impossible to give them something when the tenant is standing in front of us. Is that sufficient, or what do you suggest?
Yeah, this is the age of everything being emailed and DocuSign. I think the best way to handle that is to have some notice, some written correspondence that they agree to accept some of that. I mean, because again, I get it that people are trying to get away from paper, but I mean, I think getting away from paper is a problem in some of these areas, and email and stuff is a problem. So I don't know. Let me look at that again. I think you can email photos and videos. I don't think that's an issue. But you're saying that it has to sync with software.
Yeah, it seems like you did the inspection. Giving them the paperwork is, it's just seems not to be, covered in here. So I mean, even if in my book, I would think, look, we did the inspection. You're going to get the stuff within 24 hours.
Yeah, I think that seems reasonable to me, and I would feel good arguing that, hey, we turned it around. They're moving around. We did the inspection, and I went right back to my office and emailed it to them. I don't think any judge or referee is gonna get after you for that. So I think that can happen. But I think, you might need to think about, I don't know if the software can do it, so not a read receipt, but a confirmation email from the tenant saying, hey, I got the email with the move-in photos and the inspection form and blah, blah, blah. Thank you for that. I mean, I would like to have that in perfect world for my documentation when I'm arguing your case on your behalf. So I don't have to listen to the nonsense.
And one more thing about the move out. A different question says the new tenant landlord handbook says the inspection must happen within 5 days of move out to give the tenant an opportunity to fix. Does that mean I'm supposed to keep the property vacant for a week after that? But I think the answer to that is it's 5 days prior to the move out date, right? I mean, you don't have to. The move out's not on the 31st, and you don't have to give them 5 days after the end of their lease to fix things.
Well, first of all, I don't know what new tenant landlord handbook. I mean, I don't even know what that means. There's no such rule or law that says that. And if some new landlord-tenant handbook says that, ignore it. I don't know what else to say. I've never heard that before. Yeah. And I can't imagine. I mean, if the Minnesota Attorney General's office is pushing that, it's not the law.
I'll find it, Doug, and we'll circle back on that. So
yeah, okay. All right. So yeah, let me know on that. And again, I don't routinely look at that Minnesota the handbook from the AG's office because I don't believe it's right all the time. So remember, be careful where you get your where you get your legal advice, and I don't believe the Attorney General's office is always the proper spot for landlords. So, word of caution. Okay, so moving on. Oh, some of you probably have not run across this, but I think it bears discussion. So a tenant right now can sue a landlord for failing to make repairs. It's called a rent escrow or a tenant remedies act or an emergency tenant remedies act. An emergency tenant remedies act is saying there's no heat, no water, landlord hasn't provided it, and we need to get in court immediately. The rent escrow or the tenant remedies act talks about cases where a tenant can affirmatively sue a landlord for failing to make repairs. And what they did in the new legislation was add a couple things. Hot water, running water, heat, and electricity, sanitary facilities was in the old statute. Well, the statute now. The stuff they added was a serious infestation, a non-functioning refrigerator, a non-functioning air conditioner, if it's included in the lease, no functioning elevator, or any conditions, services, or facilities that pose a serious and negative impact on health or safety or other essential services or facilities. So the takeaway here is be mindful of repair issues under the law. If it's not an emergency in general, you have 14 days to make the repair. If it's obviously loss of hot water, running water, heat, electricity, that's an emergency. You can go in, you can try to figure it out. If it's my toilet seat's broken, you have 14 days to go in and make that repair. Be mindful though, if you don't make the repair, on day 15, the tenant can march into court and affirmatively sue you for not complying with the covenants of habitability in 504B161, which basically say you agree to fix everything, landlord, and the premises are fit for the intended use. And the premises aren't fit for the intended use when you won't come in and fix my broken toilet seat. So obviously, I think the big things that I know MHA, Minnesota Multi-Housing Association, fought against, the refrigerator and the air conditioner and the elevator. I mean, it's just a refrigerator. They can sue you for a non-working refrigerator, whether they tell you or not. It's just a little bit over the top. But so be mindful of that. And again, I go back to this, probably harping on it too much. Document. You got to have good paperwork, ladies and gentlemen. You have to. When I'm looking at your case, I'm going to ask for all the correspondence. And that means you're going to have to print off text messages and emails so I can see the emails. I can tell you text messages, even if printed off, they don't play well in court. I get two lackadaisical responses. I get terribly thought out responses. And so just kind of food for thought on that.
One of the questions, what if, as it relates to habitability, what if I can't secure a vendor with availability to complete the repairs within 14 days due to the vendor's availability? What do you do there? Like it's a roof or something like that. I mean, what do you do?
Yeah. So I didn't talk about this because this is the old law still, and it's not anything new, but 504B161 talks about the standard of repair. It's not a strict liability statute. It says reasonable repair. So what I would argue on your behalf in that situation is that the landlord has taken steps to make this repair, to get this part, to do what he or she needs to do. And that means that meets the criteria of reasonable repair. Okay. It doesn't mean it has to be absolutely 100% fixed. Now, on day 15, if you're just looking at the issue, you might have a problem. But on day 2, if you're telling the tenant, we can't get the furnace fixed because we're waiting on, X, Y, or Z, and then you're updating them, hey, I'm going to drop off some heaters for you, some alternative heat sources for you. I mean, you're doing things in reasonable repair. So remember that 161, the covenants of habitability, talk about reasonable repair. So be reasonable, take action, so that if you do go into court, I can stand up for you and say, Your Honor, we worked as fast as possible here. It's 50 below zero out there, and we're in 18 buildings have floods in them right now. So, I mean, just keep that in mind as it relates to what the standard is as it relates to that.
Jumping back, Teresa has a question about occupied, notices. So I have a tenant that's in a condo, and I need to, it's for sale. And the tenant, is an email sufficient? And with a 24 hours notice, and if the tenant says no consistently, what are the landlord's rights to allow me reasonable access for showings? I mean,
It's a good question. So this is where, and before I answer that question, because that's a good one, I also want to know that they changed one of the covenants of habitability to require landlords to provide 68-degree heat from October 1st through April 30th. So keep that in mind too. That was a little bit of a change. I mean, but getting back to this question, again, the difference is the email communication. If that's your business practice now, I think that is okay, but that may need to be addressed differently come January 1st, 2024. If you have gone to gain access 3 or 4 or 5 times, and you've documented it, and you've written a letter that said, I showed up on October 12th, 2023, and you denied me access. This is a lease violation. And you document those multiple going to the unit and being denied. A lease should say your failure to allow access is a material breach of the lease and grounds for an eviction. Now, the problem with a lot of leases is it doesn't say that. My lease says that. You can't deny, a denial of access once is enough, especially if it's during heating season. I mean, for goodness sakes, or there's a water event. I mean, there's water coming in 3 or 4 units. I mean, so remember, this goes back to something I said, time to look at your lease. You want to make sure that there is a provision in that lease that says, you don't let me in after twice, we're moving for eviction. Uncurable lease violation. You cannot deny me access. So that's the best alternative for not allow when tenants deny you access.
Doug, going back to covenant or habitability, and some of the landlords, some of our owners have Centerpoint, Home Service Plus on their things, and some of our owners want to require the tenants to pay for Centerpoint Home Service Plus, but supposedly, can we not require that? Does that conflict with the covenants of habitability? So
absolutely not. I think under 504B120, you put that above the line. You disclose it to the tenant. It's going to be part of their monthly payment, and you can contract for that service. The statute allows for you to be able to contract for that service. Now, again, preferably, I would want to draft that a certain way, and I have drafted it whereby you're kind of shifting, that burden or that repair, but it can be done. Now, it brings in a whole nother issue of when they come and and are you giving them notice that the Centerpoint people are coming? And, and that's a whole nother issue of, and does the tenants have to be home? All those sorts of issues kind of come into play, but I think as long as it's disclosed and drafted appropriately, I believe you can contract with the tenant for that service.
Okay. Great.
Okay. So just moving on. So the 14-day notice constitutes verification of an emergency. So that's the reason why, if you're going to do a non-payment of rent eviction, don't wait. Waiting to file your eviction is the worst thing you can do. I know you want to be nice, ladies and gentlemen. I know, trust me, I hear it every day. But the longer you wait, the more harm it is to you, because remember, like right now, for the tenant to be considered an emergency, we have to show up in court. So that's the first notification that any sort of rental assistance knows that the tenant is in dire straits and is behind 2 or 3 months rent. January 1st, 2024, as soon as you send a proper 14-day notice with the attached ledger saying you owe X amount of dollars, that document can be delivered to rent help in hopes that the tenant will then deliver that to rent help or the agency in question and stop you having to hire me to do your eviction. So that's actually a good thing. I mean, as it relates to trying to get you and my clients your money faster without you having to pay me to file the eviction. It's ridiculous that these agencies, we have to be in court for them to negotiate with us about a non-payment of rent eviction. It's absurd. And so I think that's a good thing. So the takeaway, do your notices fast. I'll tell you, I'll have some clients that are going to send notices to everybody on the 2nd. And that's going to piss a lot of people off. It's going to make the good residents. I'm sorry if I used that word. I should have said push.
True. It's very true.
I should have said push. My mom hates that word, so I shouldn't have used it. She always says push. It pushed me off. At any rate, it's going to push a lot of people off. Your good residents are going to get a late notice saying, but I don't know how else to do it, except tell the good residents, yeah, this is what your legislators voted in. I'm really sorry. You're a great resident, but because of the new laws, I have to operate differently. And if you're upset about it, you need to contact your legislators. So the crime-free, drug-free provision on page 3, that changes come June 1st, 2024. And that was basically because, I'll just go ahead and admit it. I drafted some language and was evicted people for conduct that happened off the premises. I don't believe that you get to rape and murder somebody in another state and come back and live at my client's property. You commit a crime someplace else, I get to evict you for it. I started doing that several years ago and was successful at it. So that's probably a Hanbery and Turner new law. Takeaway for that is keep your crime-free, drug-free in as it sits. Screen. The other big thing that I didn't want to get too much in the weeds, but it's important, is beginning January 1st, 2024, the courts are going to not require tenants. When I file an eviction and the tenant comes and they're 3 months of rent behind or 4, and the tenant then comes to court and says, I'm not paying the rent because there's an infestation and the toilet doesn't work and the refrigerator doesn't work and I withheld my rent. In the good old bad old days, the court would say, okay, Miss Tenant, you can have that defense, but you got to pay the $3,400 rent into court. We call it a Fritz defense. that the covenants of habitability and the covenant to pay rent are interdependent. So the court would say, you can have your trial, you can prove up that the landlord didn't fix anything and you gave him notice and blah, 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 but you have to put that money into court. Well, if the tenant didn't put that money into court, now the trial would be canceled and the court would issue the writ of recovery. Now, January 1st, 2024, they're taking that away. So the tenant doesn't have to escrow any rent when they come to court and present any defense. Habitability, I paid it in cash. The landlord didn't give me receipts. I don't owe it. And they don't have to provide any proof. They just say, I don't owe it. And the court sets it for a hearing. And the problem with the new law is in housing court, trials happen fairly fast. So you go to an eviction hearing, you usually have a trial within 7 or 14 days. In Hennepin, they're on a Friday usually. The problem is that the courts can take up to 90 days to decide the case. So the tenant could be living in the property, owe you 2 or 3 months rent. The case could be under advisement with the judicial officer and 3 more months click by. So it's a real problem. It's unfortunate that the law changed in this regard. It's going to make evictions very expensive. We're going to see surprise defenses. I mean, routinely, I go to court and we're at impasse, and I have the advocate say, landlord failed to fix X, Y, and Z, and there's a serious pest infestation. And I'll say, did you ever put my client on notice? Don't have to. I'm telling you today. And so I think we're going to see a little bit of that. So again, I think the takeaway is make sure your properties are in repair. I know that's easier said than done because tenants are hard on them. And do the best you can to get your notices out as quickly as possible, because again, you see how this is going to work. The tenant's not going to have the money. They're going to come to court and give me 5 defenses, and the court's going to say, well, we'll see you in trial in 2 weeks as the months of rent come clicking by. So delaying your evictions is not going to work. And that's one of the goals of the legislation. They're trying to make it so that landlords feel like, well, it's just too expensive to file. I mean, that's one of their goals. And my advice is if you're in this business, evictions and hiring architects and lawyers and CPAs, that's just all part of the business. And so very important. So for those of you that have experienced that now, it's going to be drastically changed, and we're thinking about how to fight uphill against that. So stay tuned.
So a couple of questions that have come in. Going back to this, so it's actually 504B 182 section 86 subsection 2, subsection 2, which is move out inspection within a reasonable time. You know, the no more than 5 days prior to the end of the termination of the lease. The tenant, you know, the landlord must notify the tenant that they can do an inspection for the purpose of, you know, allowing the tenant to remedy identified deficiencies in a manner consistent, blah, blah, blah. So one of the questions is, are they saying that if I do a move out inspection with the tenant 2 days before the end of the lease, the termination or the end of the lease, that I'm supposed to give them more time beyond the termination of the lease or the lease end date in order to allow them to affect these, you know, fixes that they want to do so that they don't get back charged on their security deposit? I don't know that that's.
What are you, was that statute 504B 182?
Section 86, subsection 2.
182.
I can share it on my screen if you want to see it. I mean, and if this is too long of a discussion, then we can certainly.
Yeah. Oh, you've skipped way. You skipped way.
Oh,
No.
I totally did, didn't I?
Yeah.
Sorry.
I have it here. I don't. I have one. I have 182 up, but I still don't see the.
Sorry, everyone. Messing everybody up.
I guess here's my. Yeah, I don't. I'll get back to everybody on that. Let's table that for the moment.
Okay.
I mean that's going to be the problem. I'll send an email response on that, and then you can circulate that, Scott.
Okay.
But that's going to be the problem, right? On the move outs. I mean, it's just like they're going to do a move out, and they're going to want to fix everything. They're going to want to. You're going to go through and say, well, this and this and this and this, and they're going to want to have the opportunity to fix that. And the time for fixing is past. I mean, we're doing the move out inspection on the day of move out. We're not doing it 5 days before. How could you do it 5 days before when they haven't moved out? The move out inspection must be done on the day of move out, or in the alternative, the next day. But it can't be done 5 days before, because 5 days before, as you guys all know, all their crap's still in the unit, all boxed up, ready to go. I can't inspect the walls. I can't inspect the kitchen. I can't inspect the bedroom. So I put in within a reasonable time. We give the notice, but in practice, I think the inspection takes place on the day of move out or the day after. And that's what you have to communicate to your resident.
Doug, a couple other questions. Well, two questions that probably are related. One, are you accepting new clients? And two, what is the most appropriate place for landlords to get, their updated information?
Yeah, that's a good question, and I'll probably be pretty biased by it. But yeah, we are taking new clients, and I'm not sure the place. I see a lot of people talk about going to Homeline and the Attorney General's office and all sorts of places. And I don't believe those places are appropriate. I don't believe that those places have your best interest at heart. And I'm not ashamed to say that. I say that with due respect, but I mean it. I've been doing this too long to know. And so where you get your best advice, unfortunately, in this area is a good landlord-tenant lawyer. And it means not a real estate lawyer, not an estate lawyer, not a consumer rights, not a bankruptcy lawyer. Okay, if you call me and say, Doug, can you do my bankruptcy? I'm going to say no. Doug, can you do my personal injury? No. So finding that landlord-tenant lawyer that deals with this on a daily basis is about the only place I know. And I don't mean it to be self-serving. I don't mean that way at all. But it's unfortunate, but that's just my view.
Couple other questions as we just are getting to the end here. Can inspections be done virtually? So in other words, like a move out inspection, could you set up something where, tenant doesn't live there anymore and you did it the next day or something weird like that? I'm assuming that's fine.
I think so. I think that's a good idea, actually. I think you need to be in advance, be able to make sure you can record. But the statute doesn't say anything about whether that has to be in person or virtually. Absolutely. So I think that is a good idea. Now, and even if you could be on site and the tenant maybe is someplace else or vice versa. I mean, I think the statute doesn't specify. So, but again, I would just ask you to think about how you make a recordation of that, whether you can save that virtual tour, the audio and the video. I would want that for you for in the future.
Other ones, jumping back to your comment about how you're at an impasse at court, and then they notify you right there. Oh, by the way, they've had roaches and everything like that. Is there what are the procedures that tenants must follow per the law regarding informing landlords of issues? And should we give that to the tenant at the time of leasing to basically put them on notice?
Okay, so yes, in your lease, you should have a process and procedure how they notify you for work orders. It should be a very detailed. They're to go to the portal. They're to fill out the work orders that you've dropped off or given them. They're to email you. Put that language in your lease for sure. Okay, that is key. So that details that you've got to tell me in writing. Okay, what's going on as it relates to the surprise defense on the day of eviction court. There's some new law, judge-made law that came down that basically took the position that the tenant didn't have to give advance notice of the repairs in an eviction proceeding. They could do it on the day of court. Conversely, if the tenant affirmatively sues you in court for failing to make repairs, you failed to fix the toilet and my fridge doesn't work, and they gave you that notice, and on day 15 they sue you affirmatively, they must give you a written 14-day notice under 504B381. But in an eviction where they're defending and saying the place is not habitable because the law came down, the court said there is no requirement to give notice when the tenants, to give a notice to the landlord when the tenant's in the defense position, only when the tenant is in the plaintiff position. So what does that mean? That means we're going to see less rent escrows, most likely, and less 381 sorts of petitions, and more defenses at eviction court of here's the laundry list of things that weren't repaired, and I'm going to use that as my defense. And oh, by the way, the court's not going to make me escrow rent. So I think that's what you're going to see. In the best way, the only way to try and fight against that is have a good lease that outlines the procedures and processes, so I can go into court and say, look, they didn't comply with paragraph 14. They didn't do this, they didn't do that, and that will have some legs. I mean, I think that will have some merit to a court. Like, wait a minute, Miss Tenant, you've complained, you said all these things have been going on for 4 months, but yet you're just complaining about them now. So I think that will have some merit depending on the situation. So
this is a little bit off topic of what we are, so if you need to table this, just tell me. It says, is there a limitation to what information an HOA can require from your tenant or to approve or disapprove a tenant? Has an HOA that requires criminal credit and proof of employment, everything legally, what can the HOA require, and is it legal to deny your tenant from renting out your unit for that? So
I'll give you the short answer, but I think it's the right answer. I think you got to look at the bylaws. And if the bylaws are silent in that HOA, I don't think the HOA gets to just make up the rules as they go along. Okay. So if the bylaws say, if we give you permission to rent, here's the criteria, that's an issue. If the bylaws are silent, which I think most of them are, I think you have a colorful argument to make that HOA doesn't have the authority, doesn't get to dictate screening, doesn't get to dictate acceptance. And frankly, if they do that, I think they run afoul with fair housing laws. There will come a time when these consumer rights lawyers are going to sue them for violations of fair housing. They'll probably sue the landlord too, but they'll sue the HOA as well. But that's my short answer.
And then two other questions that are somewhat related. Does Doug recommend screening yearly for long-term tenants? A law-abiding tenant may today be fine, and tomorrow they may not be. And then this is a related question. What if a tenant has more people living on the property than on the lease? What do you generally do?
Okay. So number one, yes to screening, okay, annually. If you're going to do a renewal, I would put some language in your lease that says we have the right at renewal time to rescreen you, and you will pay $40 for the rescreening, or we'll agree to not charge you the $40, whatever it's going to be. But yes, put some language in your lease. If you know anything about the affordable world, the affordable world in like HUD project-based Section 8, they do rescreening every year. So they run new backgrounds. So it's absolutely appropriate. You just need to cover your backside and have some language in your lease. And then what was the other question?
That's like one. What do you do if you have there's more people living in the property than are on the lease?
Yeah. So the old unauthorized occupants, the unauthorized residents in the building. It's an age-old question. We deal with it a lot. Number one, you got to have a clear lease. You got to document, lease violate them, and then try to understand or figure out, do I have enough evidence to bring a breach of lease eviction? How do I know that they're living there? Do I have cameras? Do I have them on video? Do I have them coming and going in the parking lot? Do I have them coming and going with pass keys? Did the resident give the keys up? Do I have them using the amenities? Do I have them, on police reports using that address, your address, as their address? So it's a facts and circumstances kind of test, but I think you should be diligent and work expeditiously to evict those unauthorized occupants really fast, because if you let them stay and the tenants continue to pay you rent, they can argue, which they have against me, that they're a regular occupant. The definition of residential tenant includes a regular occupant. So what they do is they come to court and say, I'm a regular occupant. Landlord knew I was living there. I talked to her in the hallway when I'd walk by her. She knew I was living there. She didn't care. I gave her the rent money 1 month. So remember, unauthorized occupants pose a real threat, that whether they're on the lease or not, if you don't take any action, they will become a residential tenant and cause you all sorts of problems. So get the evidence to prove they're unauthorized. And again, how about this? Simple. I write a letter to the tenant that says, we believe you have an unauthorized occupant. His name is Bob Johnson. Please tell me with a utility bill and a signed written lease where Bob Johnson lives. If you get nothing from that resident, you're getting closer, right? So again, I think sometimes we overthink this. Go knock on the door. When Bob Johnson answers, who are you? Where do you live? Why are you here? I think those are okay questions to ask under the guise that this is a serious lease violation. Now, I wouldn't do that for every situation, but when you're saying there's a lease violation, I think it's appropriate to go and ask people, who are you? Where do you live? Why do you park here all the time?
There's a related question that just came up about lease violations. Are the courts, would you recommend that if somebody's smoking in their unit, is that worth spending the money to go and evict somebody under breach of lease?
Yeah, the smoking issue is huge. And the smoking issue has gotten worse because of the new cannabis law that has come into effect. Some of our clients are moving their property smoke-free. Okay, that means smoke-free anywhere is on the property. Parking lot, four corners of you can't smoke here at all. That's probably the smart play to try to avoid the marijuana issue. Okay, smoking is a big problem. It destroys units. It runs people off the building. It disturbs lots of people. In Hennepin County, if you don't evict people for smoking, the tenant that's affected by smoking can file a lawsuit against you saying the landlord won't do anything about this smoking tenant downstairs. And we had a case where the court abated the tenant's rent for 4 months because we didn't evict this smoking tenant. And we made the determination, but that we didn't have the evidence. And as you've just heard me speak, I mean, I don't do anything unless I know I have the evidence. Unauthorized occupant smoking case. So yeah, when it comes to you better take action on cannabis, because again, they smoke weed in your property and disturb others. it's a nuisance, and you're liable, Mr. or Miss Landlord. So smoking cases are important, and we litigate those. We do evict people over smoking. Did 2 today.
What kind of evidence do you bring, or what on that in that situation?
We've had, like today or yesterday, our case was we had written lease violation notices. We had maintenance that had logged that they had been to the door and the smoke was coming. We had the tenant downstairs, the balcony under the smoking tenant. She was complaining, and she had logged and kind of diaried all the smoking instances. And so that's it. That's how we win the cases. Getting all the residents, around. And again, sometimes it's going to knock on doors. Do you smoke here? You can tell when you open up the door. I've had other residents do surveys about smoking. I mean, so there's lots of ways. Now, we'll require landlords to become proactive, talk to other residents around once you kind of figure out who's smoking. But yeah, you need to evict people for smoking cigarettes. You need to evict people for smoking marijuana. That's my view. Because remember, marijuana is still illegal federally. And I have some cases coming up on this exact issue where, we're not bowing down just because the state law says that weed's legal. Well, it's not legal in accordance to federal law. Just because there's no one with enough courage to prosecute it doesn't mean it's not still legal.
Have you one last question about that, and then we need to go, is have you had any situations yet where somebody's got a medical marijuana card and they're smoking in the unit, and then you get into this, loggerhead situation?
Yeah, I had a medical marijuana case about a year ago, and the resident kept telling me she had a medical marijuana card, and I kind of dove into it. And back then, there's only like 7 or 8 illnesses that you must have to get a medical marijuana. It's not even a card, it's a piece of paper in Minnesota. But at any rate, I dug into it, and I was trying, and we ended up resolving the case. But the medical marijuana authorization is you've got to be diagnosed with one of 8 pretty severe illnesses. And so I still believe that I don't believe it's a reasonable accommodation, even if there's a doctor that says they should smoke marijuana in the unit, because I believe that's a fundamental alteration to the landlord's business practices, which is one of the reasons why you would not grant any sort of accommodation. In addition to the fact that right now, you can have the whole gamut of edibles. And there is another alternative. So people that want to smoke weed just want to smoke weed. Why don't you eat an edible? They don't disturb anybody. You want to get high, eat an edible. So there are alternatives that are reasonable. And so so I never got to litigate that medical marijuana authorization from the state of Minnesota. But when I dug into it, it was interesting to see there were, like I said, 8 illnesses that you must have to be able to get this. So
okay, great. Well, Doug, thank you so much. I know we could all sit here I know I could sit here for hours and ask you a million more questions, but this has been fantastic. Thank you so much.
You're welcome.
Yes.
And Allison is gonna, we're gonna take this video and slice and dice it into something, and then we will send it out to everybody that has been on this call. So
Yes. Thank
I
you
hope it
so
helps.
much.
Yeah, you're welcome. And I hope it helps everybody. And it's been, I enjoy speaking. I do a lot of speaking on this and other topics. So I enjoy it. I like the questions. So I wish everybody a happy and successful 2024, but it's going to be fraught with with a pitfall here or there, but nothing we can't survive. So
that's right.
Awesome.
All right.
Great. Well, thank you so much again, everyone, for attending, and we will be in touch following the webinar.
All right.
Thank you.
Thank you.
Take care.
Have a good
Bye-bye.
day.